So today I will be talking about how to litigate truck collisions. Be going through a lot of basics, but then also a little bit more in depth. But essentially, we're just trying to explain what to do if a truck crash case walks in the door, a few things you have to do right away, and then some tips on handling them all throughout trial. So at my firm, my partner and I, Caitlin Nars, we opened a firm to specialize solely in handling trucking and commercial vehicle cases. We also handle brain injury cases. As you'll see there, truck accident and brain injury lawyers. May not be too surprising that those two tend to go hand in hand. Given the catastrophic nature of most trucking cases that we handle, it's common to see brain injuries suffered by a lot of people who've been involved in truck collisions. So those two are the main types of cases that we handle. We do have some auto cases, some dog bite cases, but primarily trucking cases. So that's what I'll be talking about today. And so this is what we do. We are active members in the Academy of Truck Accident Attorneys group. It's a phenomenal group for anyone looking to get into trucking. They have a wonderful listserv, constantly posting updates and successes and victories and how-tos all throughout the country. And what you'll find is a lot of attorneys who specialize in handling trucking cases, they do it nationally because a lot of the interplay, no matter what type of truck case you're handling, a lot of it's going to be the same state to state. Of course, if you're not licensed in a particular state, you're definitely going to want to have local counsel for a number of reasons. But that's why, as he said, we're based in Denver, but we do handle cases throughout the country. And ATAA has been a wonderful group to meet other experienced truck accident attorneys across the US. There's also a ton of phenomenal resources. They have a whole resource bank that includes deposition outlines, deposition transcripts, names of experts to work with, names of experts to avoid, essentially everything you would need to start actively handling trucking cases. I'm also a member of the Colorado Trial Lawyers Association and American Association for Justice. Again, just other groups to get phenomenal resources and meet a lot of people who have done this for years. And so next I'm going to talk about, why these cases are so important for many different reasons. One thing is these cases and the outcomes of trucking cases can influence legislation. What I mean by that is, for example, in Colorado, we were seeing a ton of Uber crashes where the Uber driver was not the one at fault. And so when you think Uber, you're thinking most likely commercial policy. They do have 1 million plus in limits, but that was solely for if the Uber driver was at fault. And if you could prove that they were in the course and scope of their employment at the time, they had an active ride going on. But with the prevalence of ride shares and in the Denver community and communities across the US, what was happening is we were seeing so many people who were getting into Ubers, assuming that they were covered. And then when it's the Uber driver who was not at fault, in which case they would need to go through what's called underinsured or uninsured motorist coverage, Uber was saying that's zero, we don't provide that. So after seeing so many of these cases, we were able to recently, I think just within the past couple years, get Colorado to pass legislation that requires all Uber drivers to have at least $200,000 per person in underinsured motorist coverage. So that was a huge win for our clients on the consumer side, because now they're protected if they get hit by an uninsured driver or someone who has the minimum limits, which in Colorado is only $25,000 per person, $50,000 per accident. Another thing is the outcome of these cases can help influence national trucking safety standards. So if there are a ton of cases that we see with common denominators in lane changes, or, I'll just use lane change for an example, it can really impact, okay, what can we be doing in the trucking industry to make the roads safer? Because it seems like a lot of these types of crashes keep happening. Can we be adding additional mirrors? Can we be providing the driver with additional support to see the car next to them, additional training, stricter regulations, stricter fines? So that's another reason why these cases can be really important. And then again, just influencing policies and practices of the motor carrier, of the trucking company itself. We're handling a case right now where we have negligent training and negligent hiring claims pending against the motor carrier and against the driver, of course, for negligence. But in looking at the driver qualification file, this is someone who has, I think there's 5 prior lane change violations. And so, if anything, if we can just get it's a case that's likely going to trial this year, but if the outcome of this case is even to have this company or other companies change one policy or procedure, like the one on lane change violations, that would be a win, because this should not keep happening. This is something that's consistently being overlooked, especially at this particular motor carrier, but it's something that can be easily avoided. It can be avoided by giving prior training, by heightened supervision, different policies, termination if it's your second violation, for example, something like that to prevent these similar types of crashes from happening. And then, of course, to hold the truck driver and the company itself responsible. Punitive damages can definitely send a strong message. So if it's willful and wanton conduct, you're typically going to be able to add a claim for exemplary damages or punitive damages. And that can certainly send a message, because most of the time, an award for punitive damages is not something that's going to be covered by insurance. And so it's something that that company or that driver, if it's against him personally, is going to have to pay out of pocket. So it's definitely something that they take into consideration when they get these types of claims against them. It can also help increase settlement value, because it knows that they're going to be on the hook for it if there is a high verdict award for punitive damages. And then, of course, the whole reason why I do this and why I'm sure other trucking accident attorneys do this is to make the roadways safer for everyone. Even, what seems like it could be a minor collision, if a truck's going 5 miles an hour and rear ends someone, that's still going to cause severe damage. It's going to cause way more damage than a passenger vehicle. So just some of the examples why these cases are so important. All right, and then talking about how these cases are different from motor vehicle collisions. There's a number of different reasons. The first one I want to talk about is the insurance that's available. The federal motor carrier safety regulations require that interstate motor carriers have at least $750,000 in insurance. A lot of times, especially if it's a smarter motor carrier, they're going to have many more layers of insurance, excess policies, umbrella policies. I think to be a smart motor carrier, you have to be thinking you need multi-million dollars in coverage because of the severe and catastrophic nature of injuries that are suffered, most of the time in 18-wheeler or other commercial vehicles involved. And then another big difference from a standard car crash case is the expertise of the attorneys on both sides. So, for example, we have a case against a national firm right now, and they literally advertise on their website that they have attorneys involved in the 24/7 rapid response team. What that means is typically the attorney or an adjuster from their insurance company is literally going to be the first person on the scene when one of their drivers is involved in a crash. And it's a smart thing to do. Unfortunately, as on the plaintiff side, we can't get involved until much later than that, but they send out adjusters, they send out attorneys to make sure that they're immediately preserving information, consulting with their driver, making sure they're minimizing their risk and their exposure as quickly as possible. But it just goes to say that they have boots on the ground immediately following a crash. So you have to know what you're up against, what to look for when you're doing inspections, which I'll get to in a little bit. But they're already consulting with their experts. They're already trying to mitigate any damages. They're trying to find a way to make sure that any exposure is as little as possible, knowing that most of the time these cause severe and catastrophic injuries and damages. And then another thing about the types of defense attorneys you'll see on trucking cases versus a standard car crash case is the way they will put up every roadblock, every barrier, every obstacle to prevent dissemination of information and examination of evidence. In these types of cases, it's extremely important to get experts involved right away. So as soon as the case walks in the door, hopefully it's within a couple weeks of the crash happening and the evidence has not been tampered with or destroyed. But you will want to have someone, one of your experts, go and do a download of the electronic data recorder or EDR and find out exactly, all there is to know about that truck that was involved in the wreck. It will show speeds of the vehicles within a few seconds leading up to the crash. It will show steering wheel inputs. So if there was any type of evasive maneuver that was attempted or taken right before this crash happened. You also will have drive cam most of the time. So drive cam or Lytics, that is an inward and outward facing camera that's equipped in most 18-wheelers nowadays. And again, it's exactly what it sounds like. It shows the inward driver's actions. So you'll be able to see if this driver was smoking a cigarette, had headphones on, whatever he was doing, if he was on his phone, looking down, distracted. And it also shows outward what's happening at that same moment. So it shows whether, if it's a rear end crash, you're going to be able to see how soon the brake lights came on in front of him. We had a pedestrian crash recently where there was a crosswalk, a button, and it was flashing, and you could see in this drive cam footage the driver's looking down. He's manipulating his radio. Meanwhile, what you see if he were to be looking ahead where he should have been looking was the pedestrian just starting to cross the road. Crazy. She did not pass away from this. She suffered very severe injuries, but luckily she did survive. But she was just run over basically by this commercial bus. And so that can be extremely powerful to show, if only he was looking up, right, he would have been able to see all of this that you can see in the drive cam. And then going back in time, why did this happen? Was he not trained on this specific type of crosswalk? Did he not receive supervision? The most important thing about trucking cases is backing up in time, because it's never going to be about this one split second, which is what the other side is going to try to focus on the most. It's going to be about all the systemic violations leading up to this, how we got here. And then, of course, severe injuries. That's another difference. The injuries sustained in truck cases tend to be catastrophic, and it's important that you continually review and that you order and review medical records while your client is treating. Because for a number of reasons, you want to make sure that they're getting the best care they can. You want to make sure there's no gaps in treatment, because if there's 2-3 week gaps between appointments and she was told to go to daily physical therapy, that's going to cause some issues, not only in the case, but in her recovery. She's not getting better as quickly as she should be, but again, in the case, because the other side, it leaves room for them to argue that something else happened in the meantime, or that this person was not as injured as she's claiming. It just opens up all those arguments that the defense likes to make. We use a service. There's many different services, but there's some like Trivent or nurse consultants that will review the records as you send them to them. So we'll get in a batch of records, especially when they're super voluminous, send them out and go through those with one of these nurse consultants, and they help us. Of course, we review them as well, but it's nice to have that extra set of eyes on the medical records, to if there's medical terminology you're not familiar with, and they'll also summarize it for you. So they'll go through and pinpoint the major diagnoses, the treatment recommendations, put it in a really nice format so it's easier to monitor and make sure that your client is getting the treatment that they need. It's also helpful to understand the severity and to be able to project out what types of experts you may want to get involved, and if it's something where they're going to need a life care plan. So it's something to start thinking about on that front. And, you're going to want to look at the medications that were recommended. So we've had clients who are scared to take medications, and that's completely warranted, but we want to make sure they're not just completely disregarding their doctor's advice. So we'll have conversations with them, ask how the treatment's going. Are you doing everything the doctor said? And if they say, no, because I'm worried about the side effects of this medication, well, then you can help them make the right decisions going forward. So, you can say, okay, you need to call your doctor and find out what the side effects are. See if there's something different they can prescribe. What are the risks if you don't take the medication as described? But again, it's all going towards helping them recover as quickly as possible, but also making sure that they're not unknowingly falling into some traps. And, later on, when it comes time for their deposition and they get asked whether they took the medication and they say no, well, then that opens the door for the other side to make a failure to mitigate their damage defense. They'll say, well, you didn't do what your doctor said. You would be better if you took this medication, et cetera, et cetera. Next, let's see, and then time and expense. Oh, just going back to the bad injuries, you also want to make sure that they're seeing the right specialist. So an example I like to give, typically everyone has a primary care doctor. That's who they feel most comfortable seeing. Primary care doctors can be great, but they're not specialists. They're not experts at a particular body part. So an example I like to give is we had a client who had been treating with her PCP. Her hand was in excruciating pain. Months later, she ends up hiring us, and we say, you really should get into an orthopedic specialist. That's someone who's going to be able to further diagnose what's going on. They ordered x-rays and MRIs, and it turned out her hand was actually broken. So it's something that seems pretty glaring to a specialist, but to a PCP, they might not always be looking for those types of acute injuries, maybe looking more overall health. And so it's important to make sure that you also have a duty to make sure your clients are getting to the right providers. And especially when this is the first time they've been in a crash, especially an 18-wheeler collision, they're going to really be relying on you to help guide them. And then let's see, time and expense. So I kind of touched on that a little bit, but right at the outset, you're going to want to get at least an engineer expert involved who can go out, do the download. That typically costs around $5,000 to $10,000 to have someone do that download and analyze the data. And then they tend to bill by the hour after that. So if you're setting calls with them to go through the information, what the data shows, that's extremely important to really know exactly what you're looking at. For example, what you think may be a lane change case may turn out to be something where you end up filing a lawsuit, including failure to stop or not leaving enough stopping distance. We had a case recently where the crash happened because the driver made an unsafe lane change, but it turns out he later testified that it was because he looked up and saw traffic in front of him was stopped. So that steering input is what will help you understand that information before you even get into a lawsuit, because that's all information that's going to be on the EDR download and the EDR report. And then potentially an accident reconstructionist. If you're getting the sense from the other side, once you open the claims and once you talk to the other side's attorney, that there's any type of liability dispute, you're going to want to consider getting an accident reconstructionist involved to talk about what the impact was of certain data that you're gathering. For example, if they're saying it's a T-bone crash and it wouldn't have happened if your client wasn't speeding, you may want to get an accident recon involved to say, regardless if this would have happened because XYZ, or human factors expert is another example. So someone to talk about based on the curvature of the road where this happened, or based on each side's familiarity with this route, was it reasonable? Would a reasonable person have been able to anticipate this person pulling out and not stopping at the stop sign, for example? Next is the fifth reason why these cases are different than a standard car crash case is there's much more multiple players. And what I mean by players is there are many other entities that can be held responsible for these types of crashes. So the first more obvious ones are, the motor carrier and the driver himself or herself, the shipper. So the shipper in a case is the one that loads and typically will secure the cargo. So you have to look at whether it's a sealed load or an unsealed load, but that's the person that loads, and then the driver picks up that load and takes it wherever the agreed upon route is, wherever the agreed upon drop location is. And they hire, in some occasions, they hire a broker to arrange transport of the load. The broker is the one that screens and hires the safe motor carrier to transport the load. So shipper may go to the broker and say, hey, I have this load, it has to get to Wyoming. Can you help us broker a deal? Can you find a motor carrier to get it there by X date? And there may be a situation where the broker hires a motor carrier that's not the safest or not even a safe one whatsoever in an attempt to get the load there quicker, to make more money, whatever the case is, but they have an obligation to make sure that they're contracting with a safe motor carrier. They're responsible for checking the safety history and the internal policies of the motor carrier. And then the motor carrier itself is the one that typically owns the cab, the truck part. It's not always the same owner of the tractor itself and then the trailer that's being pulled. Sometimes it is, but they own the cab and or the trailer, and then they employ the driver, or they have a independent contract relationship with the driver. If it's an employer, then, and even if it's an independent contractor, they have the responsibility of hiring, training, and supervising that driver to make sure that they're safe to be transporting that load. The driver is the one that carries the commercial driver's license and is responsible for knowing the rules and regulations, just like the motor carrier is, associated with driving a commercial motor vehicle. There's also the repair shop or maintenance shop. Maybe this tractor or trailer or both was in a repair shop recently due to brake malfunctions. And it was repaired negligently. That's another aspect of the case that you'll want to look into if it's a rear end case, or if there's any indication that the brakes were faulty. You're going to want to look to that entity, because there might be more liability that can be apportioned, and there might be more coverage to go after if there's another entity that could be responsible. The dispatcher directs the driver on specific travel routes. So there may be a negligent dispatch type case or negligent route selection. An example in a current case we're working on is there was a storm that came on the highway, really heavy winds, but it's an area that is known to have really heavy winds, and there's warnings all over. And this was a trailer that was unloaded. So the fact that it's unloaded or loaded is important, because it's going to affect the weight of the overall weight of the vehicle, certainly of the trailer itself. And in this case, they're claiming that it was a sudden emergency act of God type thing that caused this trailer and the truck to essentially jackknife and blow back and reverse into our client. Ironically, our client, who was in a passenger vehicle, just happened to have a dash cam, which is something else I'm seeing is more common, especially with a lot of people driving for Uber and Lyft. They're deciding to make the smart decision, I think, to include dash cams, just in case there's any issue of liability or something happens while they're driving for Uber or Lyft, they can use that as evidence. So it was very fortunate that our client had that in this case, because the officer who arrived on scene was just looking at it as our client was the one at fault for rear-ending this tractor trailer, when that's not at all what happened. Certainly he was behind the tractor trailer, but this truck just kind of blew into our client. So the other side's arguing that it's, completely unavoidable. This was just a complete shock to everybody. And this goes back to making sure that you're making the case about everything leading up to this. So it's not that this was unavoidable. This is not a freak thing. Was this a negligent dispatch case? Most likely it was a negligent dispatch, because the dispatcher of the company should have never sent an empty load out in these types of weather conditions. They have an obligation to check the weather history, find out if there's alternate routes that are safer, change the dispatch schedule. There's a number of things that we've yet to get deeper into discovery on, but that I'm anticipating is going to show that this was definitely a preventable and avoidable collision. And then you have the receiver. So the receiver is the one that unloads the cargo safely. And so it's extremely important to make sure to understand that these cases are about systemic failures on the part of large companies who try to put profit over safety. There are multiple entities that have a hand in trucks being on the roadway at the exact moment of a collision. And so these are just some of those that you should be on the lookout for. Especially not only because they may try to say that someone else is at fault, the company may try to blame it on maintenance shop, for example. It's not only because you want to anticipate all the claims you have and all the claims, all the defendants you may have, but also for coverage. If you have a company that has only $1 million in insurance or $750,000 in insurance, and you're dealing with a wrongful death case or a catastrophic permanent injury case, that's going to be very insufficient to fully compensate your clients. And so you need to be looking for those additional layers of insurance, additional negligent parties who you can potentially bring in to the lawsuit who may afford more insurance coverage. So number 6, your lawyer matters. So your lawyering and your lawyer matters. You should not file a pleading, motion, or response without consulting with competent counsel who's handled truck wreck cases. And the insurance company will most likely look you up, look up your bar number, your experience in handling these cases. And so they'll have some inclination right off the bat whether this is the type of case that you and your firm typically handle. But you also want to make sure that you're pleading everything correctly. You want to make sure there's not any deadlines or statutes of limitation that are being missed. With the prevalence of tort reform in this country, I think plaintiffs' attorneys already have an uphill battle regarding adverse rulings on pleading requirements, caps on damages, information requests, protection orders, confidentiality, all that stuff. And so another thing you want to be mindful of is you don't want to be filing a pleading that was pled incorrectly that could potentially create bad law for a bunch of other plaintiffs who want to bring a similar case. And then you also want to make sure you're being strategic on legal arguments and then overall strategy. If there's laws against not pleading direct negligence claims, for example, creative lawyering on how to still be able to talk about negligent training, negligent supervision, all those direct negligence claims against the company, there's different ways around that. And so just talking to other lawyers who may have filed similar pleadings. And I know I mentioned earlier ATAA, so they're a very collaborative group. I can't tell you how many times I've called or emailed other attorneys and they respond immediately. Everyone's really willing to help out each other. No one wants to be reinventing the wheel. No one should be. And so if you have a deposition coming up of an expert who's been deposed hundreds of times, chances are someone else may have just had a deposition with that expert. So reach out for examples on transcripts, deposition outlines. Everyone's always really willing to help in that organization for sure. And then let's see. The next one is just complexity of these types of cases. So let me just see this really quick. Okay. So an 18-wheeler is not a sedan, of course. Fully loaded, it can weigh more than 20 passenger cars together weigh. So just be thinking of that and making sure you're understanding the difference, understand how they work, how to drive them, how they run. Understanding the ins and outs of these commercial motor vehicles is really essential. I would suggest even getting behind the wheel of an 18-wheeler yourself. I was fortunate enough to be able to do that through a program in ATAA that it's kind of like a mini truck driver academy. So I think my goal eventually is to get my CDL, just so I understand exactly what every driver I depose has had to go through. But this is kind of like a crash course of that. It was only a few days, but I got to sit and drive an 18-wheeler. After doing that, my biggest takeaway is, wow, this is difficult. And there's absolutely no way in the world how you could ever drive one of these distracted. And so now, I'm definitely more critical of any distracted driving cases that I have. Not that I wasn't before, but there's a lot going on inside the cab. A lot that you have to be mindful of, tons of mirrors you have to check, blind spots you need to be aware of, all that stuff. But for example, another thing that I learned during that truck crash, crash course in trucking was we talked about pre-trip inspections. We talked about how to properly secure loads. But in the pre-trip inspection, for example, when you're deposing truck drivers, they tend to say, yeah, of course I did the pre-trip inspection required before any trip. You say, okay, how long did that take? Because you're trying to put together the timeline. The majority of responses are going to say 10 to 15 minutes. In this academy that I went to, I learned from truck safety experts that a thorough and complete pre-trip inspection should really take closer to 45 minutes, because we went through everything that they're supposed to be looking at, doing properly, everything they're supposed to be checking. And so now when I'm asking someone, did you do this? Did you do this? Did you do this? You can really attack their credibility, because you know that it's not truthful. There's no way that they're doing everything they said to do when it's not physically possible that they could do that all in 10 minutes. So just little tidbits, information like that can be really helpful if you actually have hands-on and are able to get that in-depth knowledge as it relates to tractor trailer itself. The next thing you're going to want to do is make sure you're building your authoritative resource library. What I mean by that is you want to make sure that you are getting the authoritative guides and the regulations. So everyone should have a copy of the Federal Motor Carrier Safety Regulations. It's a giant green book that I keep on my desk. I reference daily, that has all the Federal Motor Carrier Safety Regulations. And then, so that's something I reference all the time. It's also available online. So I know some people prefer online to hard copy, but I would definitely recommend getting a copy of that. It talks about part 93. So, sorry, not 93, 390. So section 49 CFR 390 talks about the general applicability of the Federal Motor Carriers Safety Regulations, or FMCSR. Part 391 is where you're going to find all of the driver qualifications, so that you can be looking for the negligence of the motor carrier, what they did not do that they should have done when hiring this person, when training, when supervising this driver. And then parts 383, 392, and 395 are going to have the quote unquote rules of the road regulations. So you're definitely going to want to make sure that you're thoroughly reviewing those. And then parts 393 and 396 relate to equipment, inspection, maintenance, and repairs issues. So that's where you're going to want to look if it's a tire off case. We've had cases where a client is driving down the highway and all of a sudden a massive 18-wheeler tire hits the windshield. So I remember before I started really specializing in trucking cases, I was like, oh, a wheel off, that must be a product case. And the answer is no, it's still a trucking case, because the truck driver and the truck company still has an obligation to do that pre-trip inspection and make sure there's no issues like that. So they have an obligation to make sure that the truck is in safe and working order. So that's how it's still a trucking case and not a products case. Certainly there may be some interplay with products if this was a tire that had a ton of recalls, something like that, but just something to be mindful of. And then you're also going to want to be familiar with the commercial driver's license manual in your particular state. So the CDL manual, that is something that's required it's required by the FMCSRs, that each state implement one of those to help a driver in obtaining. It's basically like to be the authority and support that any driver needs when they're testing for their CDL. So I would take a look at that. And then Tractor Trailer Driver Training Manual by J.J. Keller. That's an authoritative source as well that you should be familiar with. And then there's tons of other ones. There's defensive driver manuals that talk about the Smith system. There are roadside inspection handbooks. That's also by J.J. Keller. Motor Fleet Safety Manual is another good one by the National Safety Council. And as many motor carrier manuals and policies that you can find. So if you are seriously wanting to get into trucking cases, sometimes it's worth it just to review what other trucking companies are doing, what they're teaching as being safe. So for example, there's no, and I learned this at that trucking academy too, but there's no regulation specifically prohibiting U-turns by a tractor trailer driver. And however, all the safe companies, it's a terminable offense. So if you do a U-turn in your tractor trailer, you get fired immediately. So that's something to consider, just because it's not a federal regulation, but all of the safe motor carriers have it in their policy. That's something to be mindful of too, when you're trying to explain why this driver was negligent. And just as a tidbit, the reason why it's so illegal or so frowned upon, I guess, by most companies is because of the turn radius. Not only does it destroy the truck trying to make a U-turn, but it's also extremely dangerous because it takes so long to complete that type of turn. So that's why they say that you have to go pull in somewhere else and actually make a completely different type of turn other than a U-turn. You're also going to be wanting to build your digital library. So at our firm, we bookmark the URL links for all the commonly used websites. A couple of those are listed here. These are probably the ones we use the most. So again, there's the FMCSA electronic version where you can find FMCSR, where you can find all the regs, but there's also FMCSA.gov. This is where you're going to get a ton of details about the particular company that you're dealing with. So this will have company safety records, out of service orders, carrier licensing, insurance information, safety measurement systems. It will tell you how many violations they have typically in a particular for a particular offense. So they might say how many rear end collisions they've had, how many lane change violations they've had within the past X amount of years. Safer is a website that we will frequently go to right away once we get a truck case in, because that's how we locate, if we don't have a crash report already, that's how we'll locate the insurance information for that motor carrier. So it allows you to look up the company by their DOT number, Department of Transportation number, or the carrier's name. So sometimes, our client will come to us and the crash just happened a couple days ago. So the police report is not ready and we don't have it yet, but they have a photo of the truck that was involved. If the DOT number is depicted in that photo, that's great. We can easily just go to Safer website, type it in, find out who their insurance carrier is, open a claim with that insurance carrier, get our letter of representation and spoliation letters out right away. Spoliation letters I'll talk about in a little more detail, but this will allow us to get started working on that right away. Make sure the insurance company knows to preserve any relevant evidence, and we can start getting an inspection lined up. The next thing you'll want to do is start building your template library. So again, I'm happy to share as many templates as you'd like. We have a ton of resources that our firm has put together that others have shared with us as well. And so we're constantly building and revamping all of our templates based on legislation changes, based on how courts are interpreting types of things. So we have spoliation and preservation letters, for example. That's one of our templates. That's what we send out right away, listing everything that we want the company and the driver to be preserving. So for example, we want to make sure that all of the electronic logs are recorded, because the logs will say where this driver was, whether he was over his hours of service. We want them to make sure they're preserving the actual physical cell phone. So not only the driver's cell phone records, but the physical cell phone. Because what happens is we will want to get at some point in the case, whether it's right away or if they refuse to allow it, if it's once we file a lawsuit, we would like to get a forensic expert involved. So that's someone who will take the physical cell phone and do an extensive download. It takes a few hours, but they'll be able to determine not only was this person just texting or on the phone, but all the applications that may have been open at the time of the crash. Was he on Facebook, Instagram? Was he checking emails? There's a ton more information that can be gleaned from getting the physical cell phone itself. And then we've had cases where we sent out spoliation and preservation letters and then later found out in deposition that the driver got rid of his cell phone or sold his cell phone. So that opens up the door to the court, most likely, being able to grant a spoliation instruction at trial. So what I mean by that is if you can show that you sent the spoliation letter, that you requested he preserve his cell phone, and that he willfully disregarded that, you can get a strong jury instruction that says that the jury has to presume that whatever was on that cell phone was contrary to the interests of the defendant. So basically, it's like they have to presume that whatever was on there was going to be bad for him, and that's why he got rid of it. So that can be really strong as well. You're going to want to make sure you preserve any dispatch records. And again, I'm happy to share this template, but there's a ton of stuff listed in there just to make sure you're covering all bases. Because a lot of times, if the crash just happened a couple of days ago, you don't know the full extent of negligence of the at-fault driver or of the motor carrier. And so, like I said, sometimes you don't even know the exact rule that was violated, whether it was a rear end crash or a distracted driving case or some type of brake malfunction. So you're going to want to make sure all that stuff is preserved so you can further investigate. FOIA requests. So those are going to be sent out to the Federal Motor Carrier Safety Administration. And that is just going to be requesting anything related to this company, to this motor carrier in the past, like any safety violations, any warnings they've had to cease doing certain things, any time their operating authority has been suspended or revoked based on too many safety violations. A lot of good information is going to come from that, because if they've had their operating authority revoked recently, but they send drivers out anyways, they're not even legally allowed to be on the road. So you can start to argue that if this driver wasn't even if they weren't on the road like they should have been, this crash never would have happened. So that can be really powerful information to get. And then of course, pleadings. So you have to make sure you're staying up to date on the changes in your particular jurisdiction to make sure that you're always pleading things correctly. For example, in Colorado, we recently had a law that we had a law change that prohibited direct negligence claims against the company. So it prevented us from being able to claim that the company itself was negligent in training, hiring, retaining this driver if the company admits that this is their employee. So basically, that can definitely reduce your ability to show who the true entity at fault is, because the focus has to be on the truck driver. Luckily, we were able to get that overturned legislatively within the past few years. So now we're back to making those claims, but we still see a ton of motions to dismiss being filed, claiming we don't have enough evidence at the outset to meet that pleading standard to show any information that this person was negligent in training or supervising, which of course that type of stuff is very hard to get at the filing of your complaint. It's typically something you get into more once you're in discovery and once you've deposed the driver and corporate rep. So things like that you have to be really strategic about, figure out, does it make sense to include that claim at the outset? How can I get that information otherwise? Are there other pleadings that have been filed against the same company where similar acts of negligence have been alleged? Can we point to those to show that this is a pattern or a systemic thing that needs to be changed? So it's just about thinking about those pleadings. And we do file lawsuits pretty quickly in trucking cases, because that's really the only way to be sure you're getting all the information from the company and about the driver. And so just having that complaint ready to go so that you can make sure that you're timely filing that once a trucking case comes in. That's really helpful. Having a good set of discovery. So discovery questions to the truck driver and also to the company itself. Of course, those are going to be tailored to each specific case based on what the violations are, but having that good set of discovery ready to go. In our case, or I'm sorry, in our jurisdiction in Colorado, we can't serve discovery at the same time that we file a complaint. But definitely if you're in one of those jurisdictions like Texas where you can do that, of course, it has to be ready at the same time you're filing your petition or filing your complaint. And then good topic lists for depositions of the 30B6 corporate representative. We are always kind of finessing and tailoring those types of topics that we want to talk about. And I'll talk more about that in a second as well. So first, in a trucking case, we trying to think, we don't typically resolve them pre-litigation, but this is a list of things that you should be doing right away before you even file a lawsuit, stuff to do right away. So go to the scene. I highly recommend that you go to the scene of any crash. You will be shocked at the type of information that you're able to get by just being boots on the ground at the scene. There's signage that may not have been captured in the photos that may say no left turn or no turn right on red, things like that, that may really impact the liability in your particular case. There are also witnesses who may not be listed, but if you go to the scene, you start asking around if there's tons of businesses or houses in the surrounding area, you do some door knocks. We've found Ring camera footage that captured a crash in the past. So stuff like that may not be indicated or looked into by the responding officers. So you might have an opportunity to get the entire crash on video. Definitely start capturing Google Earth images of the scene, more so the scene location, but that can be a start to at least get a sense of what is this area like, what's around here, are there schools, churches, businesses, was there a school zone that was immediately before the crash that may have some impact on how fast this driver was going. So that can be helpful in really understanding and getting your bearings on what's happened. And then you want to request the entire law enforcement file. So not just the police report, but typically you'll have to make a separate request for other investigation items, such as the 911 audio, the CAD report, which is computer aided dispatch. That's going to be the report that's probably the most precise regarding when the 911 call came in, who was the person that dispatched the officer, what witnesses called it in. That will typically have that person's name and their phone number. A lot of times that information is asked in the 911 audio as well. So definitely those can be super important to find out witnesses that you may not know about otherwise. Photos, especially when it's a severe or catastrophic crash, there's going to be a very thorough investigation. There's going to be a lot of times a disc that we get with how voluminous all the photos taken are. And that way you'll have all the photos of everything involved in the crash, especially if there's any discrepancy, like for example, where the crash happened. You'll be looking for tire marks, skid marks, where certain objects ended up that were inside a car or inside the truck, broken glass, stuff like that. And then if there's a corresponding criminal case, so for example, if it's a vehicular homicide case or even reckless driving case, you're going to want to request a copy of any criminal or traffic charges that are pending. So sometimes that information is not releasable until the investigation is completed, but you'll at least want to get that request out right away so that as soon as anything's releasable, that you get a copy of that file. Because that will have typically more statements from witnesses. It will have the probable cause affidavit is going to be super helpful. For example, we're dealing with a case right now and we got a hold of the probable cause affidavit, and that says that the at-fault driver had a Bud Light wristband on his wrist. And so that is going to be important because it tends to indicate that he was coming from some type of bar or party or restaurant, whatever the case may be. But then you're thinking, okay, is this a potential dram shop case? Was there an indication that, is there surveillance that we need to get from the bar that he was coming from to explain why, or to show that he was visibly intoxicated and overserved? And then in that case, you're looking at a potential claim against the bar for under the dram shop laws. And then you're also going to want to do a request for the post-crash inspection that was done by Department of Transportation. Anytime there is a crash involving injuries, the DOT is going to do a post-crash inspection. And so that's something that's going to be important and helpful to establishing liability and showing any immediate injuries that were reported. You're going to want to review the crash report thoroughly. So make sure you're looking to see whether it says your client was wearing a seatbelt, whether, that's a big one. And that's also something that's shown in the EDR download. It will show whether the seatbelt was in use. And so if you're in a state like Colorado, where not wearing a seatbelt can affect the types of damages you're able to claim, that's going to be something you want to know at the outset. So you know maybe where to focus your damages or where to focus your injuries once you get to trial. And then searching news articles and social media posts about the collision. That's another thing we do right away, is just pull all those, save them all in PDF, save screenshots of all the articles in case they disappear later. Or reach out to the reporters. We've reached out to reporters who've covered some of these bigger crashes and gotten their take on what happened, gotten from them some witness information, some more details that may not be reported that you think are important, but that the general public might not care about. They can be helpful in that aspect. Sending preservation and spoliation letters to the driver, their insurance carrier, and the company itself. So definitely making sure to send it to the driver individually and not just the insurance company, because again, that goes back to the issue. If later there's something that's not preserved that you had requested be preserved, you want to be able to show that you sent the letter, certified mail, return receipt requested, addressed to the actual driver, and proof that he got it and still chose to completely disregard that request. That's really the only way that you're going to be able to show that this was, well, not the only way, because he might testify that he did it, but it's going to be certainly very helpful in getting a judge to give that type of spoliation instruction. And then a open records request to FMCSA. We talked about that one. Ordering the driver motor vehicle driving record and background check on the driver. So that's another big one, especially if you have a heightened pleading standard in your jurisdiction. So in our jurisdiction, for example, we have to have some basis for alleging, everyone has to have some basis, but we have to plead with specificity each of our claims. And so, it's kind of hard to just blanketly say they were negligent in hiring if we don't have anything at the outset to support that. So getting a copy of the driving history, driving record, and the background check, that can be extremely important. So in our case, for example, this person had 3 recent driving violations for lane changes. And so certainly we can use that as some support at the outset that this company was negligent in hiring him, negligent in training, and negligent in supervising, when the facts of our crash are he, for a 4th time, was negligent in switching lanes. Searching the SAFER website, we also already touched on that. That's where you can locate the insurance company. And also list on the SAFER website the registered agent in every single state. So if it's an interstate motor carrier, they are required to designate a person who can receive service of process in each state. So, if you have a case that happened in Wyoming and you're primarily practicing in Colorado, but you want to make sure that this preservation letter gets to the right person immediately, you're gonna definitely want to make sure that you go on the SAFER website, find out who that registered agent is in Wyoming, and get it sent there. And then the client's injury photographs, and preliminary medical records and bills. One thing that goes consistently undiagnosed that we've seen is head injuries. A lot of times in the ER, that's not something that providers are looking for in a ton of detail. You know, they're kind of just seeing, are there any broken bones? Are there any obvious injuries? And so getting a copy of the medical records right away and looking at the Glasgow Coma Scale, or looking at the details about how the client was presenting, how he was responding to questions. There may be some indication in there that there's a head injury, or, you know, concussion, mild traumatic brain injury, whatever you want to call it, and that needs to be further looked into through a neurologist or other specialist. So essentially, you know, more likely than not, your truck wreck team will include an investigator, whether that's someone in-house or a contractor you work with, to be doing the Google Earth captures, talking to witnesses, going to the scene, someone to do the EDR download, someone to download the data from the truck itself, a mechanical expert if there's any indication that this was a brake malfunction or a loose tire case, whatever it may be, a forensic expert to do the cell phone download, potentially a reconstructionist if there's liability issues, and human factors, we talked about that. So those are experts to get involved right away. And then also keep in mind that most jurisdictions do not require the other side to agree to allow an inspection. I have found that in, I would say 99% of our cases, the parties can agree on that before filing a lawsuit, because, you know, the other side knows that that's something that they're going to have to do once a lawsuit's filed. And if there's any way for the other side to avoid a lawsuit against their insured or their client, they're going to want to try to do that in most cases. But then you also have the attorneys on the other side who are extremely bullish when it comes to that, and they just put up every obstacle, assuming that you're essentially just going to go away. And so be mindful of that. A lot of times, you know, we send the letter of representation and then we immediately get a call from an attorney, because they're going to retain counsel pretty quickly on the other side. But I would just try to have a frank conversation, you know, say, we need to get an inspection done. How do you want to handle that? You know, here's when our expert's available. Here's when our office is available. Typically, you're going to agree to allow them to do a download of your client's car. Most passenger cars nowadays have that capability if it's not an extremely older vehicle. So you're likely going to agree to mutual inspections, coordinate the time, coordinate any parameters, and then how that data is going to be shared with the other side. And so most attorneys are fine with that. Some will force you to file a lawsuit first, but sometimes that just is what has to be done. But at least start that discussion early on to see if you can get that agreed to before filing suit. That will definitely help frame your arguments too, because you know, you can see exactly what was done wrong in there. And then keep in mind that a lot of the evidence does go away or it changes. So if you know, you request that they preserve the truck, they're going to want to get the truck back out on the road because they're losing money with that truck sitting in the lot. So that's another reason why defense counsel will likely most of the time agree, you know, hey, can we get this download done as soon as possible? We know it's something you'll be entitled to in litigation. We need to get this truck back on the road. It can't just be sitting here pending potential litigation. So that's another thing to consider. And then also be considering the possibility or the likelihood. What happens in most cases is once that truck does go back on the road, some of that data gets written over. If there's another collision, for example, it could completely overwrite the prior collision. So if you are retained months after a crash happens and you go out and do a download and it doesn't show anything related to this crash, that could be one of the reasons why, is because they hadn't received a spoliation letter. They didn't preserve the vehicle, didn't have any pending claims against them, sent it back out on the road, and that data was lost. So just another reason why it's important to get those letters sent out and the inspection done right away. And then this is just some of the information that we request be preserved. Again, it's not an exhaustive list, but this is some of the most important stuff that we're going to want to make sure they preserve. So driving logs, driver qualification, all prior incident reports, satellite tracking information, maintenance records, pre and post trip, and the relevant portions of equipment. So anything that may have malfunctioned and led to this crash happening. In preparing for litigation, here are some of the most common types of truck collisions. Distracted driving, lane change, rear end, nighttime driving. So in most CDL manuals, you'll see it talks about how nighttime driving is riskier than daytime driving for a number of reasons. Of course, hazard perceptions are harder to see at night. It's harder to see in general. Visibility changes at night. Backing, so unsafe backing. One of the things I did when I went to that trucking academy was I also tried to back an 18-wheeler up. I'm much harder than it seems, or maybe it just seems very hard. I was surprised. I don't know how people do that, but definitely would require a lot of training. So we deal with a fair amount of unsafe backing cases. Unsecure cargo, so that comes into play when you're dealing with, was this load secured properly? A lot of times the truck driver will do that very hastily because all that time, that downtime that they're spent securing their load, they're not getting paid for. They get paid by the mile most of the time. And so, and also it could affect their delivery schedule, right? So a lot of times you'll find that they are securing cargo much too quickly to be safe. And so that leads to unsecure cargo, falling off the truck, usually flatbed trucks, falling off, and that's what causes the injury to your client. And then left turn, right turn, and U-turn cases, brake adjustment cases, emergency stop, and then conspicuity. Conspicuity is, a lot of times you'll see that at nighttime, but basically it's when they don't have reflectors on their trailer. And let's say a tractor trailer is turning out of a private drive and doesn't have any reflectors or doesn't have triangles out if they're backing up into a highway. Many of those things they shouldn't be doing just generally, but it's just as an example. A lot of times a driver will just be driving down the road and not see that hazard crossing the roadway right in its path until it's too late. So that's what's meant by conspicuity cases. And then hazardous or adverse weather cases, those are really common. But again, almost always there's something that could have been done to avoid that. Maybe in Colorado mountain conditions in the winter, they weren't abiding by the chain laws, which require all commercial vehicles to have chains on their tires in a certain stretch of I-70. Maybe they didn't anticipate that. They didn't look at the weather reports beforehand. They didn't choose the safest route. So those are all examples of hazardous weather condition cases. And then preparing for litigation. Here are some of the common causes of actions that we plead. So negligence per se, listing out the specific local statute or federal statute that's been adopted by your jurisdiction and showing that that's negligent per se. Respondeat superior, negligent entrustment, entrusting someone with a vehicle that they know is not equipped to handle that vehicle. Negligent hiring, negligent training, supervision, retention, and maintenance. Sending out a driver in a car that's not maintained properly. So I'll go through some of these in more detail. Negligent hiring, of course, is when the employee is incompetent or unfit to drive a commercial motor vehicle, and the employer knew or should have known of this employee's particular incompetence, but hired them anyways, and the employee's incompetence or unfitness was the proximate cause of the injuries. So, for example, 49 CFR 391, that's the regulation that sets forth the minimum qualifications for truck drivers and the minimum duties of motor carriers in employing such drivers. So a driver is prohibited from operating a commercial motor vehicle unless he or she is at least 21 years old, sufficient English, is proficient in English and has sufficient English to respond to official inquiries, is experienced and trained necessary to safely operate the same type of vehicle that they're going to be operating at that company, is physically qualified, and that's defined in more details, has a valid commercial driver's license, and is not disqualified from driving a commercial motor vehicle. And then not required is a road test. Certainly that's an industry standard that should be followed, but it's not necessarily required by the rules. But most safe employers will make sure that there's a road test done as well before hiring and putting someone out on the road for their company. And a subsection of the same regulation requires employers to obtain the driver's motor vehicle record for 3 years within 30 days of employment. So they have to look into their prior driving history. There's never be a situation where they claim they had no knowledge of prior violations, because they have an obligation under the federal regulations to make sure they're requesting those records. And then they also have to have a valid medical examiner certificate. So a certified medical examiner has to examine this person and give them the all clear, basically confirming that there's no physical or emotional limitations that would preclude this driver from being a competent commercial driver. And then they also have to reach out to prior employers for references to make sure that there's nothing that would disqualify them that came up in a previous job. Negligent training. So every employer shall be knowledgeable of and comply with all regulations contained in this subchapter. And it basically is saying that the driver shall be instructed regarding and shall comply with all applicable regulations contained in the Federal Motor Carrier Safety Regulations. So applicants have to certify that applicants, meaning the companies, have to certify that they have a system and individual responsibility for ensuring compliance with the FMCSRs, that they have in place a driver safety and orientation and training program, and that they require all their drivers and ensure that all their drivers are familiar with DOT regulations governing driver qualifications, and that they have in place an adequate system to make sure that that's being monitored. And that they also have in place policies and procedures consistent with U.S. Department of Transportation regulations. Some other causes of action. So negligent supervision. This comes about when there's failure to reasonably monitor or control the actions of an employee. If a trucking company knows one of its drivers struggles with a substance abuse, for example, and continues to employ him, it is likely to be liable under a theory of negligent supervision if that person causes an accident while impaired by drugs. Negligent retention is a breach of an employer's duty to be aware of an employee's unfitness and to take corrective action through coaching, reassignment, or termination. So an example is if a driver is consistently violating his driving logs, but the company continues to retain him and he gets into an accident because he's over his hours of service and he falls asleep at the wheel, that's going to be a strong negligent retention case. They should have gotten rid of this person for all of the violations, and that specific violation was the proximate cause of this crash. And then negligent maintenance. No commercial motor vehicle shall be driven unless the driver is satisfied that all the parts and accessories are in good working order. So that goes back to the pre-trip inspection that has to be done before the driver drives anywhere. Inspection, make sure it's repaired properly and maintained properly. So now to drafting the pleadings. What I would recommend starting with is pulling your jurisdiction's jury instructions or jury charge. That's going to be extremely important because then you know exactly what you're going to have to prove once you get to trial. And so you want to plead accordingly when you're filing your complaint or your petition. and know your strongest theories of liability. Make sure those are all included. Cite to the authority, cite to the Federal Motor Carrier Safety Regulations, cite to local statutes, especially if you're trying to get the negligence per se arguments in, where the jury can just be instructed that if you find a violation of this, you must determine that the defendant was negligent. That can be really strong. And then reference facts that support your claim. As much as possible, you want to be able to reference specific facts. And this can be done by getting a copy of the defendant driver's driving record for the past few years, see if this is some type of pattern, and talk about all those other prior instances to support the claim of negligent training or supervision. If there's any criminal history out there, if this person has substance abuse problems or has been charged with many DUIs, certainly that's something that would come into play, especially if it's a drunk driving crash that's involving your client. So you're going to want to make sure that you tailor your discovery request to your specific case. Nothing is more obvious that you're not really sure what you're doing, as it is if you send boilerplate discovery requests that aren't specifically related to your case. So you want to, this is where knowing the regulations really well comes into play, making sure that you know exactly what you're entitled to get, so that once you get those boilerplate objections in response, you can be prepared to cite why you're entitled to those, what the regulations require the defendant preserve, for how long, what they're required to maintain as far as records go, why those are relevant to your case. And then if they still fight you on it, you're prepared to set a discovery dispute hearing or file a motion to compel, depending on your particular judge's, what they prefer you do if there's any type of discovery dispute like that. And then you also want to be thinking, what do you need at trial? So who do you need to testify? What testimony do you need? What do your jury instructions say? Again, knowing those really well and knowing exactly what you need to prove from the outset can really help you streamline discovery and make sure you're getting everything that you need. And then again, just let the federal regs be your guide when it comes to all the information. If they say, oh, we don't have his logs, we don't have this driver's logs from that day, well, that's a violation of the FMCSR because they're required to keep those for a specific amount of time. All right. And then another thing to keep in mind is a carrier is liable for both the actions of its drivers in submitting false documents and for its own actions in accepting false documents. So also be thinking about the authenticity of those documents and whether that's something that there's going to be a dispute about, because then you're going to want to consider taking the deposition of the records custodian or someone else who might be able to talk about that. The driver qualification file is a big thing to get. So that's going to have typically everything about this particular driver. It's going to have his hiring. So it's going to have his application for employment. It's going to have any driver counseling or any reprimands that he's received, any violations he's had on the job, anything he's been terminated for while working at a prior company, because that's something that his current employer had a duty to investigate. It's going to have a list of where he's held commercial driver's licenses, all the states that has been held in. It's going to have the DOT medical examiner's report. It's going to have training certificates so that you can see what he was trained on. Usually there's sign-offs on what policies he's been trained on, what particular procedures, everything about this driver to be able to determine if this is a safe driver, and then what his qualifications were and what his employment history looks like. I'm going to touch on working with experts next. So we've talked about engineers a lot. Those are the people you want to get involved right away to do the download. Some other ones we haven't talked about yet are transportation safety and compliance. So anytime you have negligent training or supervision or retention claims against the driver, you're going to want to be considering Is this something where you need to get a safety and compliance expert involved to talk about why these were particular violations? You know, if you have, if you're trying to say that it's negligent, that this company was negligent in hiring, well, it can definitely bolster that by getting an expert involved who's familiar with all the FMCSRs, who can pinpoint the exact ones that were violated, who can come testify at trial as to what a responsible and safe motor carrier would have done, what the industry standard is, the insufficiencies in their internal policies and procedures. Once you get those in discovery, you know, if they don't have a policy on distractions, but their drivers keep getting into crashes because they're using their cell phones, I would say that that is evidence of negligence on the part of the company. And that's something that their safety expert would be able to talk about. Forensic experts, again, those are the ones to do cell phone downloads, for example. You may want to talk to a DOT medical examiner if there's something in this driver's history. For example, if he has like sleep apnea and it's a fatigue case, and you think that he's someone who never should have been qualified to obtain a CDL, you might want to talk to other DOT medical examiners to find out exactly the types of questions they ask, why this person would have been disqualified under standards, that type of thing. And then it's a whole nother topic on vetting and retaining experts, but make sure before you hire anyone that you put together a budget. That's going to be important. You want to make sure it's someone who's specifically been referred or recommended, whether it's on a national or local listserv, but then you're going to want to vet them yourself. So you're going to want to ask about what their experience is, whether they've ever had their testimony limited or excluded. Because last thing you want to do is be paying an expert tons of money and then the defense to pull up all these orders where they've been disqualified from rendering the same opinion. That's not going to help you at all. So make sure that it's someone reputable. And budget's important because you should always be considering, you know, what is this expert going to cost all the way through trial? And is it something that this case can afford based on the damages and the claims that you have? So they might charge, you know, $8,000 for a report, but if you get the report and the case doesn't resolve still, you know, are you looking at how many thousands more to get all the way through trial, including this expert's travel expenses, deposition costs, all that. So that can be super important. And then we have an internal expert database where anytime we see expert recommendations, we're just adding those to our list and saying who recommended it, where it was recommended, in case, you know, we get a case tomorrow and we want a safety and compliance expert, for example. Well, now it's easy to reference this list. Okay, here's some recommendations. Let's start calling them, see who would be best for this particular case. All right, next is deposing the truck driver. I'm coming up on my time pretty soon here, but we'll talk about this one. So in any deposition with a truck driver, these are some key things you're going to want to ask about. And again, I'm happy to share deposition outlines, but you're going to want to ask about their background, their education, medical history. I mean, medical history you probably can't get into unless it's glaringly obvious in your case. But, you know, if the defense's argument is that he had a heart attack, you know, you're going to want to make sure that that's confirmed and see if there was anything leading up to this that would have been an indication that a heart attack is likely or imminent to happen and that he shouldn't have been on the road. His experience, the driving experience, is this someone who's had a CDL for one day or who's worked for this company for 10 years and never had any issue? So that's going to be important. And then again, looking at the driver qualification file. You're going to want to ask about this particular trucking company. So how did this driver find this job? You know, where is that full application? Was this something that was posted on Craigslist or Indeed? Was this something where, you know, it's his brother's company and he hired him without doing any background check? Just more details on how he came to be working at this particular company. And then you're also going to want to ask about his familiarity with safety standards and other regulations. Is this driver familiar with his state's CDL manual? If he's an interstate carrier and frequently drives between Colorado, Arizona, Wyoming, and California, how does he make sure that he's staying up to date with all those local laws? Because he has a responsibility to follow each state's laws as he continues to travel interstate. And then specific details about this particular crash, but also the events leading up to it. What time did he wake up that morning? What time was he supposed to be at the place where he was dropping the load? Just some key questions, his familiarity with the route. Some key questions to really pinpoint, okay, is this something where he was speeding because his load was to be delivered in 2 minutes, but he was, 15 miles away, whatever the case is. And then responsibility, whether or not they're accepting responsibility or if they are denying liability. And either one can be good. If he says, yes, I was negligent, I should have left more distance, that's fine. That's good for your case. If he says, no, I don't think I did anything wrong, this was unavoidable, that's also good for your case because it shows that he wasn't trained properly. It shows that he had no idea what a safe stopping distance was to leave. Your state's particular CDL manual. So the FMCSR's section 383 in particular, it requires each state to provide an FMCSA pre-approved driver information manual to any and every CDL applicant. So essentially, the other side likes to argue a lot of times that the CDL manual is not law, it's merely a suggestion. But in that situation, I like to bring up that section 2 of every state CDL manual talks about driving safely. And it says this section contains knowledge and safe driving information that all commercial drivers should know. So regardless, it's something that each state has adopted and said, this is something you should know. So it's kind of hard to get a driver to disagree that it's stuff that should be followed when that's the whole thing that they were trained on in the first place. That's the whole way they were even able to get their CDL. And now they're saying that, oh, it's not that important. It's not law, it's merely a suggestion. So either response is good for you because it goes to either their credibility or they're going to admit that it's something that should have been followed. And then here's just some kind of sample questions to ask the company. Especially if, for example, the company's saying, this driver followed all of our policies, he didn't do anything wrong. The CDL manual is, merely a suggestion. Okay, well, what resources would X company point to as authoritative on how a driver should handle this type of situation? What training materials does it reference? Because more likely than not, they're going to be referencing the CDL. And if they're not, you also want to find out what they're training their drivers on. And then this is kind of a wordy slide, but it's a bunch of questions to ask the driver as it relates to the CDL manual. But essentially you're trying to get at, this is a professional driver. This is someone who has way more standards and rules and regulations that they have to be following than a standard passenger, a driver of a standard passenger car. They're certifying that they have the knowledge and understand the driver safety rules and industry standards found in the CDL manual, and that they're competent and equipped to be able to drive such a heavy vehicle. Witness depositions. So here are just some quick examples of people who are going to be important to depose, or who you might want to consider deposing at least. So any favorable investigating officers, of course, are going to be helpful to your case. But if anything, even prior to depositions, consider calling the officer. You have nothing to lose in talking to the officer who investigated this report, this crash. So we will reach out to the officer. Typically, their name, badge number, stuff like that is in the report, and then we just Google them, find them, set up a time to talk or email. A lot of them have emails, so it's easy to coordinate that call. But it's really informal. You're essentially just wanting to get their take on stuff. So we had regardless of whether liability is disputed, but we had a case recently where our client was a truck driver and he was chaining up his car. It was during a storm and another vehicle crashed into him and killed him. And so one of the things we wanted to know, of course, right away is, was he doing anything wrong? Was this a designated chain station? Was he standing in a spot where he should have been? Was there a safer spot that the other side may argue he should have been in? And so we called this officer, and he was able to confirm and answer all of our questions. He said, he did absolutely nothing wrong. On this particular day, there were a ton of other vehicles because it was a heavy storm. There were a ton of vehicles chaining up at the same time. There was a quote unquote more safe chain station, but it was completely full. So it was already full. So of course he did the exact thing that any other truck driver would do. He continued on to the next one. It was only a mile or so up the road and was in the designated area. And this driver who hit him was just speeding, going way too fast for conditions, was visiting from out of state, unfamiliar with the 4-wheel drive laws at that time of year. And so it was helpful to talk to that person. Emergency medical professionals, especially if there's a dispute over whether your client was wearing a seatbelt, for example. Well, if you can talk to the person that says, I was the one that cut the seatbelt off your client, that's gonna secure any issues with whether your client was wearing a seatbelt. And then any independent witnesses, independent damage witnesses. So that's people in your client's life, friends, family, other church members, coworkers who knew your client before and after the crash, who would be great to talk to informally via phone conversation, find out how they would present at trial, and then potentially consider deposing them or calling them as a witness at trial. And running short on time, but of course you're going to want to depose the 30B6 representative. So because you're dealing with the company, you're going to need someone who can actually speak for the company. And in this, I would plan way ahead before you're thinking of noticing the deposition of the corporate representative, because what you're going to do is you're first going to put together a topic list, because the corporate rep has a duty to make sure that they designate someone who's knowledgeable of all the topics that you want to talk about. So it takes some time, often going back and forth with the other side to get those squared away. Because if there's any objections to the types of topics you want to discuss, you're most likely going to have to set a hearing with the court to see if those are appropriate or to see which way the court rules. But yeah, that's why I say plan ahead for those. But it's someone who can speak for the company and their answers bind the company. So that's going to be important. If this person says our training policy says XYZ, that binds the company. So then you can talk about what this company does for its training policies. And then just quickly at trial, really try to simplify. Jurors want to know the stories. They're not so much concerned about the tedious details or with specific violations that were violated. They generally want to know, is your client a good person? Was he doing anything wrong? And then could this have been avoidable? Which many times it can be in truck cases. Decide what the case really is about. If it might be a case where your client was lucky that he wasn't more catastrophically injured. But maybe it's not about the injuries. Maybe it's about all the missed opportunities to train this driver appropriately. And that's why you're at trial that day, is because to show what the company could have done better. So that's it. This is what we do. We're here to support you. I'm more than happy to chat with anyone at any time. If you're new or seasoned truck accident attorney, if you want to run a case by us, and that's a picture of me at that truck academy that I was telling you about. But yeah, we enjoy this. We're passionate about it, and more than happy to share outlines, transcripts, however we can help you, because I've been fortunate to get a ton of mentorship from others, and I know no one should be navigating these waters alone. So thanks for having me.